Today's feature speaker, Zack. Zack's a PhD researcher at the University of Southampton. Actually, he has submitted his thesis, so congratulations, Zack.
Thank you.
He specializes in crime and punishment in the British Army during the Napoleonic Wars. He's previously written on morale in the British Army during the period, popular public attitudes to the Peninsular War, and relations of command and control between Wellington and those who served under him. In 2021, he released an edited collection, The Sword and the Spirit, Proceedings of the First War and Peace in the Age of Napoleon Conference. He's the host of the podcast, The Napoleonicist, one of my favorite podcasts, and co-host of the podcast History Hack. And he is the inaugural chair of the Napoleonic and Revolutionary War Graves Charity, an organization committed to burying veterans of all nationalities from the period 1775 to 1815, whose graves have been disturbed, and also maintaining existing graves of those who have served. So without any further ado, please welcome Zack White. Zack, it's all yours.
Thanks very much, Tom. Folks, good afternoon, good evening, and wherever you are in the world, thank you for giving up your Saturday to spend some time listening to me just witter on really about crime and punishment during the Napoleonic era. I'm conscious that there's been a very long line of distinguished guests on the program, so I'm hoping that I won't end up lowering the quality or the tone this evening. Today, like a cliche presenter of a 90s TV documentary, I want to take you on a journey. But unlike a cliche 1990s TV presenter, it's not a journey through history. It's a journey through a process. I want to talk to you about the way in which crime and punishment actually worked. I'm by no means the first researcher to have an interest in crime and the law in the British Army during this period. Accomplished individuals such as Charles Oman, Arthur Gilbert, Roger Norman Buckley, and more recently, Tim Lockley and Will Tatum have all sought to shine light on very specific elements of the process, giving us windows into what military law sought to do and how it may have functioned. But nobody has ever examined the military system as a whole from the ground up for an extended period of time. And that's where my PhD came in. Using a database of almost 9,500 cases, I tracked military law, not quite in its entirety, but nearly over an 11-year period from 1808 to 1818. And tonight, I want to show you the reality of how that law operated, what it felt like to be caught up within it, whether as a victim, as the accused, a prosecutor, or a judge. I want to guide you through that journey from committing a crime to defending yourself in court, all the way to the punishment parade square. In the process, I'm going to show you a system that is far more complex and more nuanced than we have ever previously recognized. The images that you see in front of me, particularly the one on the right, probably represent the limit of most people's knowledge about military law. But it's one side of a very complex system, a system built around a frustrating, messy mix of complexity, accountability, and discretion that prioritized pragmatism at every single level of the Army's command structure, even if none of those levels could agree on what a pragmatic approach to discipline should actually look like in practice. Above all, I'm going to show you a system that at once embraced the practices of its bigger brother, of wider civilian society, yet also kicked against them where necessary, because it sought to do one thing more than anything else: serve the Army's needs. And in that it succeeded, but as we'll see, at a cost. So what are we actually dealing with here? Don't worry, I'm not about to go into a complex mix of Latin as I kind of take you through these things, although there was a little bit of Latin in the way in which this worked, but not in terms of the implementation. So military law, it basically derives from two documents, the ones that you can see on the left-hand side of the screen. The first and the most important, I would argue, is the Mutiny Act, or to give it its full name, an act for punishing mutiny and desertion and for the better payment of the army and their quarters. Not perhaps the most catchy name, but it does what it says on the tin. It's reviewed every single year by Parliament, which means that it's one of the most scrutinized pieces of legislation in Britain at that time. And crucially, it allowed the king to then issue the other important document that you can see on your screen, the Articles of War, or for another kind of long and decidedly uncatchy name, The rules and articles are for the better management of His Majesty's forces. Together, those are the fundamentals, the legal basis, the written framework from which everything that happened in terms of army discipline was based upon. Any trial had to refer back to these and be very specific about which section and which article of the law had been contravened by the charge that the accused was facing. Military law was therefore written, and written, in the case of the Articles of War, in a language that was very plain and easy for all to understand. That's part of the reason that the Articles of War exist. The Mutiny Act, as a piece of statute law, is quite complex in its construction. The rules and Articles of War are for the layman. What that therefore did is it stripped out all of the legal terminology and phrased a number of the important provisions of the Mutiny Act relating to offences in a way that could be understood by all. And that's important because these articles were read at the head of every regiment every 2 months. They were a working document which supplemented the law with other key orders for the running of the army, but which explicitly outlined a total of 65 types of crime. And yes, I did go and count them, don't judge me. But they also explained the consequences, crucially, for those who were caught breaking military law. On top of all of that, that kind of written, regularly scrutinized foundation were additional orders, the things that you would expect as part of the day-to-day running of an army. So, as you can see on the right, I've got a section on unwritten law. Essentially, any verbal order that was given by an officer was legally enforceable, provided it didn't contravene an order from a higher authority. There are times where that happens. So if, for example, a lieutenant ordered his men to tear down the roof of a convent for use as firewood. Now, if you've spent any time reading memoirs of the Peninsular War, you'll know that British soldiers were particularly prone to doing this kind of thing. And the reason I use this example is because exactly this kind of thing happened. Now, tearing down the roof of a convent for firewood was not, surprise, surprise, accepted and legally viable. And there was a case where an officer had ordered his men to do precisely that and therefore had to face the consequences for it. Now, Wellington, as a British commander of British forces in Spain and Portugal, had issued an order contrary to that. So verbal orders and the written general orders kind of represent different stages in a hierarchy. As you can see from the other cases of written orders, you've got the general orders. These are published every single day. These can relate to the mundane things. And those of you who know Wellington will know he was an incredible micromanager who could tell you, the proportion of grains that needed to be enough horses' feed and the amount of hay, and don't use freshly cut hay because that's going to cause upset stomachs and so on and so forth. But there are also very specific stipulations about what the troops shouldn't be doing. The general orders also contained summaries of the trials that took place within a force, again kind of re-emphasizing this point not only of what the law said and what was expected, but also what the consequences were if you ended up breaking it. You've also got standing orders. These are usually issued within regiments, and the general orders and the standing orders were collected together in published volumes that officers were expected to buy at their own expense and familiarize themselves upon joining a regiment in the region. So there was no basis upon which you could claim ignorance before the law, because if you hadn't apprised yourself of what the law said, or if you hadn't been paying attention during the parade every 2 months where the Articles of War were read to you, that was very much on you. So the last of the technical stuff before we start dealing with some of the nitty-gritty, the court structures. We've covered the legal basis, but there are different tiers of court to get your head around. Before 1812, it's nice and simple. There are two of them. The General Courts Martial, what I will call throughout this court the GCMs, and the Regimental Courts Martial, the RCMs. There is a third tier, the General Regimental Courts Martial, which were created in 1812, and they aimed to address some of the more serious cases that you would normally try at a regimental court martial. Now, the GCMs, the General Court Martials, are the most senior, the superior tier of court, because they're the only one that can try officers, and they tried the most serious crimes committed by NCOs and privates. So we're talking things like mutiny, murder, repeated cases of desertion. The GCMs are the only court that legally, and you do get cases where people sort of try and fudge things and it doesn't work out at all because of the safeguards that are built into the system. But legally, this is the only court that can issue the death penalty. It has the power to inflict the most severe floggings. The legal theoretical limit is 1,500 lashes. There's a question that I always get asked: to what extent can 1,500 lashes kill a man? Honest answer, nobody actually knows for sure. There are two ways of looking at this. Well, firstly, the reason that nobody knows is because nobody's experimented to see what the medical impact is of inflicting 1,500 lashes on a human being. And the court records and the registers don't make it clear what happened to the individual post-punishment. The flip side to that is that, yes, if you inflict 1,500 lashes on somebody, in theory, that could destroy their back and potentially kill them. But if you wanted to execute somebody, you have the provision to do that under the Articles of War. So why would you flog somebody to death when you can shoot them to death? And both take place publicly. So both achieve the same thing in terms of public spectacle. So I'm always a little bit kind of hesitant to say that 1,500 lashes is the equivalent to death by flogging, because that's not the purpose of a flogging. The flogging is there to make an example of a crime that is less serious than those crimes which merited execution under the law. Now, the other thing to say about the 1,500 lash limit is that it's never actually issued in the period that I've examined. So the highest that's actually sentenced and inflicted is 1,200 lashes. Now, it was possible in the early part of this period for a soldier who couldn't remain conscious for the full length of his punishment to be allowed to recover for a few days and then have the remaining lashes inflicted. But that changed, and there was a lot of discussion about this within Parliament. And by 1811, there's this consensus that actually you just shouldn't do that, and that wasn't actually legal. But that's very much about legal interpretation. The other thing to mention about the 1,500 lash thing is that in 1807, King George III, so no higher authority than the king himself, tried to influence punishments that are being handed out by the GCMs by stating in an official comment when he reviewed the case, because the king had to review all of the cases that took place at the General Courts Martial, that in his decided opinion, no corporal punishment should exceed 1,000 lashes. So in one sense, that's quite significant. He's reduced it down by a third. In the other hand, 1,000 lashes is still one heck of a punishment. The trouble was, that wasn't a direct order, which means that punishments could exceed 1,000 lashes, and in fact, they did. Next up, we have the RCMs, the Regimental Courts Martial. These are, as the name kind of suggests, the trials that take place within regiments. They deal with much smaller scale crimes, things like drunkenness, instances of absence, occasional sort of insolence or a little bit of insubordination. They are initially capped at 500 lashes, but then that limit is reduced by the Commander-in-Chief, the Duke of York, to 300 in 1812. And then the middle tier is the General Regimental Courts Martial. You can see how they came up with the name. Legally, they could inflict 1,500 lashes because there wasn't any explicit demarcation on that, but in practice, they never issued more than 1,000. They were created, as I say, in 1812, but that creation, and this is very much symptomatic of how military law operates during this period, is very, very haphazard. You would expect, if you're going to create this new type of court, that the people writing that legislation would have turned around and had a conversation with the Judge Advocate General's Department, which is the department that has to administer military law and check the proceedings and make sure that it runs smoothly on a day-to-day basis. It's quite clear that that really didn't happen, to the point that the Judge Advocate General's Department is left kind of scrambling, trying to find people to staff General Regimental Courts Martials once that relevant alteration to the Mutiny Act has been passed. So that's your basic structure and where it comes from. As I say, this was a known entity by everyone in the army. You didn't need to be able to read to know that you would be held to account. And more than that, this was visual, because these punishments were public on the parade square. Summaries of the GCMs, as I say, were published in the general orders. Floggings are conducted in public. So there was no question of what could happen to those who broke the law. So let's start on our journey proper and ask ourselves an important question. With such an obviously brutal system, why on earth would somebody contemplate breaking military law? To us, sitting here in 2022, this seems like an incredibly draconian system that is vicious in the way that it operates. Now, there's an important caveat there, which is actually this is an age where flogging was being phased out and certainly where confinement was being phased in, but it is an era where you have public executions. So people are, I wouldn't say immune, but they're a little bit more used to seeing very public displays of very brutal punishments. But let's put ourselves in the mind of the criminal, because actually that might sound like a kind of grandiose thing, but it's not quite as difficult as you might think. And we'll start with the crime which was most widespread, which is plunder. Now, if you've ever read a memoir of a member of the rank and file from the Peninsular War or from the Waterloo campaign, or really any of the campaigns from this period, you will know that plunder was pretty much endemic during this period. It doesn't matter which one you pick up, you will probably find an anecdote either confessing to plunder or recounting someone else doing it. But this crime, at least in theory, carried the death penalty. So why do it? Well, the answer to that isn't black and white, but we start straight away by drawing a distinction between plunder for subsistence, i.e. surviving, and plunder for profit. And one of the most eye-opening books written about the British Army during this period is really helpful on that. And it's this, Ed Coss's All for the King's Shilling. If you want to understand a lot about what motivates the British soldier during this period, read this book. It's stellar. Ed covers a number of issues, including combat effectiveness. I'm going to talk more about that in a moment, unit cohesion, morale. But I want to dwell for a second on his very detailed nutritional analysis. Ed looked at what soldiers were burning nutritionally day to day as a result of their work, the marching and so on. He then worked out how much they were physically getting from their rations. And there's a deficit. In other words, the troops weren't getting the sustenance they needed from the army in their rations. And at times, they weren't even getting their full rations. So essentially, the troops had a choice here. You can plunder for food, or you can starve. They are literally between a rock and a hard place. So once you accept that there is a need for troops to plunder in order to keep themselves alive and keep themselves doing what they need to do on a day-to-day basis, you start to then blur the lines, because that distinction between plundering for subsistence and plundering for profit ended up becoming very dangerously blurred. I'm going to turn here to Private Jeremiah, who served during the Waterloo campaign, and he offers a very candid account of a foraging expedition. Foraging was a lovely little euphemism that the troops liked to use. They had a few of them. Actually, the officers had this thing where they described stealing as making, and they had this little habit, and they get together in little groups and kind of show off the wares that they'd managed to find. And it's usually sort of little trinkets, little spoons and crucifixes and things that they found along the way. But Jeremiah talks about this foraging expedition that's happening in the midst of the Waterloo campaign. And essentially, he's gone out looking for food. The troops haven't had their rations. You know what happens in the Waterloo campaign. It's pell-mell, and they haven't been fed. But in the process, yes, great, he manages to find some wine and some flour. And so he concocts this little idea that he's going to make wine dumplings, which sound delicious. But then Jeremiah spots a dog that's been tied to a chair in an abandoned mansion. And so he goes to unchain it. But in the process of doing so, he discovers that the straw that the animal had been lying on contained 2 bags full of silver dollars. Now, Jeremiah had a choice. He could leave those dollars there and maybe they'd get found by their owner, or maybe they'd get found by some other entrepreneurial forager. Or he could pick them up, line his pocket, and let's be honest, who was going to know? Because the mansion was abandoned, and so he took that opportunity. And that opportunism is another element of why plunder happens. The pay is very meager. It's often in arrears, sometimes as much as 6 months in arrears in the case of the Peninsular War. And you've got this point about there are very limited consequences in a war zone where you have the army marching on day by day, moving on geographically, which therefore means that by the time the complainant has spotted it, by the time the victim of this crime has discovered the fact that that sack of dollars has gone, well, the army's moved on. What are you going to do? You can try and complain to the local adjutant and say, well, I had some money, and without any proof, without any observation, it becomes very difficult to prosecute that crime. So the opportunism is definitely an element of it. But there's something more complex here, which is about a culture of plunder for reward. Troops believe that they were owed something for fighting hard. If you read William Lawrence's account, his autobiography of his time in the Peninsular War, you will know that prior to the siege of Badajoz, he and his mates specifically plan a crime spree that they're going to unleash the second they are through the breaches. They know what happens in the aftermath of a siege. They know that plunder is a thing that happens, and they believe that it will be permitted. And so the three of them hatch this little plan. One of them manages to secure a length of candle, and they work out between them where were the little silversmith shops from the last time they were quartered in the town, and they work it out. They are going to hit these shops. They have planned their crime. Similarly, William Brown, his account was published fairly recently by Hellion. William Brown was a really good soldier up until the Battle of Vittoria. If you're familiar with the Peninsular War, you will know what happened at Vittoria. King Joseph's abandoned baggage train was plundered, and many of the troops managed to line their pockets. But in Brown's regiment, a couple of days later, the unit was paraded, and all of the plunder, all of the stuff that they couldn't account for, was taken off of them. And Brown was absolutely apoplectic. He considered that plunder to be his right. In his mind, he had fought for it. That was his legitimate reward for him risking his life, because his pay in his mind wasn't sufficient to match the effort that he was putting in. And so off the back of that, he made a commitment to absolutely raise hell and to line his pockets and take every benefit he possibly could in every single scenario that arose. And you see this fundamental sea change in how he approaches his job, from being fundamentally a good soldier to really just being an absolute piece of work, and for an officer, a nightmare to handle. So that covers plunder. Let's talk about another type of crime, desertion. This is one of a series of acquitants that you can see on the S.K. Brown Collection website. And they tell a little bit of a story, and I'm going to use a couple of them over the course of tonight. Yes, granted, they're from 1791, but still close enough for this period for us to get a little bit of a flavour of the nature of the deserter during this period and the reasons why they might choose to desert. And you've got a really obvious example right in front of you: family. So this sequence talks about a recruit who is seemingly sort of forced to enlist or cajoled into enlisting, then has second thoughts, thinks of his family, tries to escape, and is then captured, as you can see in this scene here. That broom looks like it's about to make contact with the officer's head if somebody's not very careful. So the thing about desertion is that there's a very murky line between desertion and absence, and nobody really knows where that distinction lies and where the boundary is. And this is quite a problem in terms of officers choosing whether or not to try somebody for desertion or try somebody for absence. And what you see is quite often they will fudge the system, and somebody who will have been absent for weeks or even years in some cases. And I have a case of a guy who was absent from his regiment for 10 years, who was tried under a lesser category of charge in order to basically avoid the smear of trying a deserter and having a deserter associated with the regiment. There's a complexity to all of this, though, which is a notion called primary group theory. Now, primary group theory was something that was put together by Maurice Janowitz and some of his predecessors, and the concept was first come across in the Second World War, when a group of psychologists interviewed soldiers coming off the front line in Normandy, and they started questioning these soldiers about what was motivating them. And what they found is it's basically the mess group. It's the people that you eat with, that you march with, and that you fight alongside day to day that keep you going in combat. Now, why is this relevant to desertion? Well, the point is that you have these units that are incredibly close, and they are mutually everybody in that group is mutually dependent on one another for survival. Now, if one person breaks away from that by running off, by deserting, you're basically turning around to the rest of your group who are depending on you and saying, I don't care about you anymore. I am putting my own concerns before yours. And the flip side to that is that you will therefore be ostracized from that mess group, which matters from a survival perspective, because they are sharing this plunder. They are sharing the food that they find. So if you don't want to be part of that mess group anymore, you're not going to share in the spoils either. And so survival is very much tied into the extent to which you're willing to be part of that. So if you're willing to break away and put your own concerns first, then you are foregoing the support of your colleagues should you be caught and should you ever return to your regiment. There are all kinds of commentaries that have been made on desertion. Kevin Lynch has made the point that most desertions probably took place within British regiments, where units were based within the British Isles, and that, as this print suggests, the problem usually affected new recruits, which is why there's quite a rush to get people sworn in so that they are tied into a regiment and can't just sort of take the money, take the bounty money and then run off. Joseph Cozens has also made quite a convincing case that desertion was often not a random drunken mistake, but instead was a calculated move. And I would agree with him on that. But there's an important point here, which is that even if desertion wasn't a drunken mistake, it didn't mean that it wasn't used as a mitigating defense. And this is really quite clever. And throughout this talk, I want to use a few Canadian examples as a nod to the host organization tonight. So my first example comes from Canada in April 1814. And it's the case of Thomas Lambert, who employed this drunkenness defense when he was charged with deserting from his post towards the enemy, a different crime from plain desertion. Deserting towards the enemy was more dangerous because you were definitely foregoing any kind of association to king and country. So deserting towards the enemy when on picket duty, advanced Lord Prescott, on or about the night of the 2nd of March, 1814. Similarly, Private James Smith, John Williams, and Joseph Widdows were tried in Quebec on the 10th of September, 1816, at a general regimental court-martial for desertion. All three of them acknowledged their guilt, but they claimed to have been drunk when they did so, and then they threw themselves on the mercy of the court. This is a very calculated move. They're recognizing guilt of another crime, one that contains a flogging sentence, but they're using it to ameliorate another and saying, look, I did this, I confess to this, yes, I was absent, but I was drunk at the time. And then what you quite often see is that they turn around and play military law at its own game and say, I knew the penalties for desertion. And so when I came around the next morning, I was scared of coming back because you hang deserters and you shoot them. So actually it's military law's fault. It's not my fault at all. It's all a very clever and complex game. Can we believe them? Well, I'm not entirely sure that we can. The effectiveness of the defense varies. In Lambert's case, he was found guilty of deserting his post, but not guilty of desertion towards the enemy. So he therefore escaped being shot, but 5 of the 14 officers who judged that case felt that flogging was appropriate, and he was sentenced, only 5 thought that flogging was appropriate, so he ends up being transported for life. In the case of Smith, Williams, and Widdows, they all received 800 lashes. Though 3 of the 9 officers wanted 999, very specific number, or 1,000 lashes. Certainly in Widdows' case, we can doubt whether or not he was being truthful, because he was convicted of desertion again 7 months later. So I'm not entirely sure I believe the drunkenness thing. But what I really want to fixate on for a moment here is the employment of that defense and the frequency with which it's done. This shows there is a knowledge amongst the rank and file of how you get off these charges. This is how you escape military law. And the fact that there is that knowledge shows that this is an organic system that is known and that is manipulated even by the rank and file. They can assert a degree, granted, but certainly a degree nonetheless, of leverage on this system, which shows that it is not simply a case of the ruling class, the officer class, having complete control over these men. There is a limited degree of agency from the rank and file that shows there is give and take within this relationship. Another thing that we might want to consider, and I want to do this very, very briefly, is this classic scum of the earth misconception. The reason I want to just spend a moment on this is because there's been a little bit of a discussion. Well, there's an ongoing discussion, not least, did Wellington mean it? Simple answer is yes, he did. He repeated the quote on 4 separate occasions. The first one is this one. It is quite impossible for me or any other man to command a British army under the existing system. We have in the service the scum of the earth as common soldiers. Everybody says it's about the plundering post-Victoria. Yes and no. It is about plundering, but it's about plundering that's happening a week after Victoria, resulting in more complaints from the locals who just want life to go back to normal. And so it's not about they plundered the baggage train. It's about I can't get these men back to regiments and they're causing me a massive headache. He repeats it again in 1831 at a series of dinner parties, and everybody goes, well, it's a backhanded compliment. Yes, it is on that occasion. But he, as I say, he repeats it on 4 occasions. And in a parliamentary inquiry into flogging in 1836, he again talks about how the army is drawn from the lower orders. Now, he's not right. This is Wellington and his aristocratic arrogance and a disdain that he has for the working class. As, again, if you'll see, if you read Ed's book, actually, it's very clear that it's the labouring class that ends up being drawn into the army when times are hard. And so this idea that the British army is made up of the pickings of the prisons is not the case. Yes, there were ways in which you could escape an execution or a transportation sentence if, once you were convicted by a civilian court, you agreed to sign up to the army. But actually, looking at the Old Bailey records, those cases are quite few and far between. So I'm very reluctant to kind of ascribe to this whole thing of, oh, they're all just, reprobates and rotten apples. You get a few rotten apples within each regiment, no question. But that is not to say that the entire army is staffed with deplorables, as Wellington might have chosen to describe them. But what's quite interesting here is the way in which you can draw a direct line between Wellington and his fears and concerns and this print by William Hogarth, a very famous one called Gin Lane. And when Wellington is talking about how the army is drawn from the lower orders in the 1836 parliamentary inquiry, he's referring to this issue of drunkenness. Now, was that fair? Were the rank and file all drunk all of the time? Honest answer, no. There is a point to be made that, yes, they get issued with alcohol as part of their rations, but it's meant to be small beer. So it's not enough to make them sloshed half the time. That doesn't mean that it wasn't a coping mechanism. You've got to bear in mind what the privations that these troops are experiencing day to day. And certainly the idea that, you hand round a skin of wine by a campfire when you've marched for a heck of a long time and you're incredibly tired and you just want to go to sleep has its kind of seductive qualities. Was there a culture of drinking in the army that was kind of judged by the mess group? Probably. Teetotalers were kind of associated with Methodism. There's a lot of stigma attached to varying religions during this period. And so people would have been encouraged to share in any plundered wine. Drunkenness was certainly a common crime. It wasn't the most commonly tried offence, though. It's only something in the region of 7 to 10% of cases. Something else that actually, no, let's move on at this stage, just taking a quick look at the time.
Zach, can you take a moment for a few questions? We've got a number that have accumulated.
Yeah, of course. You can break now if you want.
Sure, just for a few moments.
Yeah,
Chris?
Please.
Thank you. So, Zach, there's been quite a few questions about desertion and absence, sort of your last major theme. So I'll start there if that's all right. So after an action, or the question was specifically after an action, but I'm considering marches, that sort of thing. Straggling, would that be considered an absence to the military?
This is the thing about absence, desertion, and where does the categorization lie? There's a lot of grey area. The army does prosecute desertion and absence more than any other crime. It amounts to about 35% of general court-martial cases, about 60% of general regimental cases. After an action, though, you've got lots of very logical reasons why you could excuse having been away from your unit. So, you can say that you were taking a wounded soldier back. You could say that in the heat of the moment, the gun smoke and so on, you became separated from your unit and you lost them and you didn't know where to find them. And so you spent days wandering the countryside trying to re-find your unit. You might have just actually ducked and run. But this is where the judgment process within the mess group comes in, because if you were to do that sort of thing, it would be noted that, this is somebody who isn't prepared to take the risks with the rest of us. So in theory, yes, absence wasn't permitted, but you've got a heck of a job proving it. And the cases where you start to see people being tried for absence/desertion are usually cases where it's very clear cut. An example would be the siege of Ciudad Rodrigo, where a number of deserted soldiers are found inside the town and they're in French uniforms. And therefore, it's very clear that actually they deserted a long time back. And immediately after Ciudad Rodrigo, they are prosecuted and they're shot for their crime before their own regiments, to send that very clear message. But usually in the aftermath of an action, you don't see prosecution for absence.
Interesting. Thank you. So I'm wondering about that primary group. Would they be, I guess, questioned, right? If we're trying to examine somebody's, whether they're absent, whether they're deserted, whether they fled in an action, was there sort of an investigation? Would it happen, or was it more sort of a streamlined process, I guess?
You've got a really complex problem here, because on one hand, if you're part of that mess group, you don't want to be the snitch, because if you're the snitch, you won't be trusted. So you find that these groups are very tightly knit, and there are some brilliant anecdotes of officers trying to break apart the mess group. And Wellington thinks this can be done. He thinks that you can persuade one guilty person to turn evidence, what's known as king's evidence, and snitch on the others in order to escape punishment. The reality is, and Wellington talks particularly about that within relation to Plunder. The reality is that when it comes to desertion and absence, it's only taken to court if it's a very clear-cut case. And you see that desertion trials are usually the shortest of all of them, because yes, you will call on people to testify, but usually it's not so much from the primary group as a sergeant who has to take the roll call in the morning and can verify that I took the roll call in the evening, he wasn't there. I took it the following morning, he wasn't there. Then I saw him being brought in 3 days later by a dragoon escort. And if you've got a couple of people who can confirm that story, then you can prosecute. What you tend not to see amongst the rank and file is discussions about, certainly within court, about whether or not, so we call Private X, who's the buddy of Corporal Y, and, will you testify that this guy said he was going to run off? You don't see that happening. That doesn't mean that there aren't conversations at a regimental level prior to that to work out who can they call upon to act as an evidence. But generally, if you're going to prosecute somebody for absence or desertion, you're going to make sure it's a senior NCO who can just do something very basic and clarify that the records say he was absent.
Interesting. That takes me in a different direction, but I'm going to save that for later if there's time at the end. So I'm just going to do one more now, if that's all right. So Marcus was asking about the primary group theory again, and how that affects a group that we think of with very high desertion rates, such as the Chasseurs Britanniques. We know that they have very high desertion rates. So did that primary group theory break down for them? Can you speak to that?
Yeah, Chasseurs Britanniques, generally speaking, foreign inverted commas units have higher desertion rates than British inverted commas units. And I use inverted commas because it's always very fluid. With the Chasseurs Britanniques, you've got to bear in mind that they're a unit that is staffed with deserters from the French army. And so what you've got coming in here are a group of people that you can't really trust, because did they desert because they wanted to join the coalition cause, or did they desert because they just wanted to get away from the army? And actually what they're going to do is either desert back when they don't like the conditions in the British army, or are they going to then desert into the countryside in order to get away from the front line entirely? There are no hard and fast answers, but the reason that you see so many desertions from those units are because they're not invested in the cause. And actually a lot of those people who are deserting are people who've deserted already, and they're just not plugged into either because they're not invested in the regiment, they're not invested in the unit, they're not invested in the wider kind of concept of success of the army. They just want to get the hell out of Dodge, which you can sympathise with, certainly. But yeah, that's your reason why with the Chasses Britanniques.
Interesting. And so perhaps they haven't even developed that primary group to the same extent. I just want to turn to everybody else in the chat. I've got lots of great questions. So thank you. Please keep them coming. But I'm going to ask Zack to keep going with this presentation, and we'll try to bring some more up at the end. Thanks, Zack.
Sure, no worries at all. Yeah, as I say, keep them coming. And, if you don't get the chance to ask a question, you can always find me on Twitter. My Twitter handle's at the bottom of the screen. So we have some insights into crimes that were committed. Now let's think very quickly about getting caught. The theory here is very simple. If you're an officer or an NCO, you should know these are the men that you live with day to day. These are the men that you have direct responsibility for. You know their quirks. You see things. If any of the audience have been teachers, you will know that, again, just hanging around these people, you see things. Certainly in the case of students, you see naughty kids doing things that they shouldn't. And that's the nature of living with people in a position of responsibility. Now, they should have therefore intervened. It's quite odd, though. The Articles of War don't explicitly state that if you fail to investigate, that in itself is an offence. The closest that the law gets is that officers are meant to, quote, keep good order and to the utmost of their power, redress all such abuses or disorders. If you don't do that, you get cashiered, in theory. Equally, if a civil magistrate was to come to you with details of one of your men having committed a capital crime or having used violence against a person or property, then the officer should offer every assistance possible to said civil magistrate. There is an open question about the extent to which that loophole of, you're not personally responsible ends up being utilized and exploited to create a live and let live approach to discipline, with the troops kind of being let off the hook and crimes being ignored because of the nature of command and control. We've talked already about this tension about primary group theory. I won't dwell on it too much, but what I will say is that these men get cuts of whatever is plundered. So if you're plundering for food, if you're plundering for money, that all goes into a central pot, and you're all meant to get a share of it. Whether that's a case of, Private X plunders a handful of dollars from a Portuguese peasant and therefore goes to a local wine shop, buys a skin of wine, and passes it around the campfire. This is a system where you share the spoils, inverted commas, of war. So there's investment on that level. And we've talked already about how you don't want to be a snitch. But the officers are duplicitous in this on multiple levels. And I don't just mean turning a blind eye, although a blind eye is appropriate when it comes to this extract. This is from William Wheeler. He's talking about his commanding officer at the time. This is from March 1813, a Major Roberts. Now, he admits elsewhere that Major Roberts was fond of the lash. This was a guy who liked to use the cat of nine tails to instill discipline within the regiment. But he has an odd way of dealing with this soldier who sought to disguise himself when he was robbing an elderly lady of some eggs. The simple solution was to, quite simply, shut one eye. He's feigning that he's blind in one eye. The woman sees the crime being committed. The soldier runs off, but she complains to the unit's CO. And so the major parades the unit, and with the elderly lady, he walks up and down the line. When they get to Barnet, though, who is the thief, and I'm going to quote here, she looked steadfastly in his face and exclaimed, "Jesus Maria Joseph, I never saw two more alike. Only the man who stole my eggs was falta un ojo," Spanish for had one eye. She's completely, as you can read the rest of the anecdote here. She's completely befuddled. She doesn't make the connection. But crucially, the major, who can see all of what's happened, doesn't help her to make the connection. And I want to dwell for a moment on the last bit. that the major recommends to Barnet not to try that trick again, because if he had ordered Barnet to shut one eye, the old woman would have identified him. So what you have here is a major, the commanding officer of a regiment, deliberately not helping in the prosecution and the detection of a crime, and therefore in the process being responsible for the committing of that crime. He's complicit within it. The fact that this is coming from somebody who is a harsh disciplinarian speaks volumes about this whole thing, about a pragmatic decision being made about how hungry are the troops and what crimes are worth prosecuting, what is worth intervening with. It gets worse than that, though, because the officers are also in the business of stealing things. Now, that doesn't necessarily just have to be money, it can be food as well. And you have this obvious tension because there's a hypocrisy going on here. So in the case of, this is from the 71st Regiment, an anonymous soldier recalls how there's a mill by a riverside. The troops are grabbing flour and stuffing it into their haversacks. And the major, it's the colonel, who rides up, sees what's going on. And he has a very simple way of making sure that he catches everybody who's responsible. As they all run out the door, he lobs handfuls of flour at them, parades the unit, and will spot the ones who have flour on them as a way of making sure that they can be picked out, taken to one side, and then prosecuted. Except that, as he's doing it, a live hen pokes its head out of his pocket. He has plundered a chicken alive and stuffed it in his coat pocket. And it's just one of those farcical scenarios that you get in war, where he's walking up and down the line, railing at these men, giving them what for, and it just becomes a farce. He doesn't understand it until the major rides up and says, you've got a live chicken poking its head out of your pocket. You might want to do something about that. And the colonel is forced to acknowledge his hypocrisy. And as this anonymous individual says, the millers were no longer looked after, i.e., they weren't prosecuted. I could give you others. There's a whole question about to what extent was it a good thing to share your plunder with officers? To what extent did officers even expect that? There is a whole culture here of people being told that they can go and plunder, either because the officers need breakfast. There's a farmhouse over there. The officers need breakfast. Go do your thing, and then you'll get some of the leftovers. I won't dwell on those accounts tonight, but if you want me to share those sorts of things, then please drop me a line and I'm very happy to do so. You've got a very obvious tension here. You've got self-interest, you've got pragmatic concerns. There isn't a universal approach. This is not, the law says you will be prosecuted, therefore I will prosecute you. And that's the important takeaway from this system. Discretion is absolutely everything. So that's the situation from the officers. I want to spend a moment talking about the Provost and the Staff Corps of Cavalry, because these are the other people who are meant to be sort of on the front line of crime. The Provost, they're woefully undermanned for the job. They're meant to be drawn from the most steadfast of soldiers within a division. The reality is, particularly in the case of Edward Costello, we can doubt whether or not that was really the case, because Costello openly admitted to casual plundering on occasion. So perhaps not the most steadfast of people and not the type of person that you want apprehending others committing the same crime. But there are something like 2 provost marshals, there are 8 provost marshals as a whole at Army headquarters in late 1813. You generally within each division have 1 assistant provost marshal at any one time. Now, in January 1811, there are 4,057 men of all ranks in the 3rd Division. In terms of trying to actually detect and apprehend these criminals, regardless of how zealous you were in the prosecution of your duties, it just wasn't feasible. So in 1813, you have the creation of these fellows, the Staff Corps of Cavalry. These are under the command of George Scoville. They're an extension of the Corps of Mounted Guides, and these are sort of the early ancestors alongside the Provost of the Royal Military Police that we have today. If anybody knows of where the archives for the Staff Corps of Cavalry are, if they even exist, I would love to know them where they are, because I cannot find them for love nor money. But Wellington himself acknowledges at the moment at which he sets these guys up, which is something that he has to lobby for with the commander-in-chief and get special permission to do it. As he sets them up, he says, if they were 3 times the number, they wouldn't be able to carry out the job that's before them. Such is the nature of plunder within the army. Essentially, what happens then is that once you're detected, you're placed under arrest. If you're an officer, it's not close arrest because of a whole kind of situation regarding the commission. If you were to break your arrest as an officer, you would be cashiered for that, and so you would lose the money that you'd invested in your commission. So that's kind of deemed to be the fail-safe. For the rank and file, it's a different story. You're placed under close arrest. Details of your crime is then sent to the regimental commander, charges drawn up, and this is where who detects you becomes quite key, because if you're found by a member of your unit, by an officer within your unit, the commanding officer of that unit has the ability, or the officer who finds you has the ability to frame that charge. So if you were found as a deserter and they just want to pass it off as absence, they can do that. And the reason that is beneficial is because desertion should go upstairs to a general court-martial. Absence can be tried at a regimental court-martial and kept very quiet. You then get orders such as these, convening, in the case of general court-martial, something like this. Notice that the total number is 14 officers. This is a fail-safe, so that if one of the officers falls sick in the process of the trial, they can carry on with the trial whilst having the full powers of the court. If you have 13 officers and one falls sick, you can't issue the death penalty. You have to be very careful in terms of other punishments that you issue. So there are kind of measures in place to make sure that the court retains its power over the course of the trial. The other thing I just want to emphasize, the deputy judge advocate, which you can see in the bottom paragraph there, that's the guy who has to form the case for the prosecution. He's also the guy who has to advise the defendant on how to construct a case to take down the case for the prosecution. So he not only puts together the case for the prosecution, he advises the person who's got to defend themselves on how they pull apart the case that he's making. Massively conflicted system that isn't resolved until much later in the 19th century. It's an open question whether or not that creates a conflict of interest. It's not very clear. You don't, however, see people receiving assistance from external legal advisors, from lawyers. It is permitted, but it's very rare that it ever actually happens. And lawyers are not permitted to address the court. So all they can do is sit there and whisper in your ear. They can't cross-examine a witness. There's a question, therefore, as I just skip that, there's a question, therefore, about to what extent, with these courts being staffed by officers, that military law is a system where you are judged by your superiors. Now, if you're a general, that's not the case. You are judged by your juniors in many cases because you're so high up the system. But for the rank and file, no, you're judged by your superiors. There's no question about that. The reason being that you couldn't have privates under the system that operates within the British Army at the time, judging their superiors, judging officers. That's not something that British society is going to tolerate. The question really is that anything new? And I would say no. Douglas Hay and others have kind of made this point that within civilian legal courts, you're always being judged by those above you anyway. To be on a jury during this time, you have to have a freehold of £10 a year. So actually what's operating in the military courts is no different from wider society. Who do you have in the courtroom? I'm just going to dwell for a moment on this beautiful Gilray. This is connected, it's actually a little bit earlier than our period. It's from December 1782, and it depicts the trial of Lieutenant General James over the siege of Minorca. The reason I particularly like this is because, like all Gilrays, it just has little digs, extra capacity over the two who've fallen asleep. You've got the guy who's just lost the will to live on the right-hand side. Attention sits above the guy who's obviously fallen asleep but is trying desperately to disguise it. Was this a thing? Yes, in some cases it was, because for officers, those defenses could go on for days. and be very long-winded and very verbose and call many, many witnesses, to the point where we have occasional references of even the judges presiding over these trials just quietly conducting their own correspondence on one side, because they are so bored of the tedium of these trials. And you can tell, if you're ever in the National Archives, you can tell the difference between an officer's trial and a private's trial just by the weight of the documents that you're handling. You know, you've got documents this thick for officer trials and, you know, a few sheets of paper for privates. Now, in terms of how this works, it's all about evidence, as you would expect. Witnesses are key to this process, but you only need one witness to secure a prosecution. Now, this surprises Francis Larpent, who is sent out to the Iberian Peninsula to assist Wellington in the conduct of trials, because the British Army out there is just overwhelmed with the number of cases. And what they find, can I just ask, how are we doing for time, Tom?
We are 1 hour in, so
Okay.
we can forge on a little bit, and then I'll add, anyone watching, if you're pressed for time, you can pause this and come back to it, or you can revisit it tomorrow and come up to the spot. So, you know, it's quite commonplace we run over the designated time. Maybe we should start specifying there an hour and a half, but then I think they might run closer to 2 hours. So carry on, Zach.
Okay. Essentially, just to emphasize, Larpent is very surprised by the fact that you only need one witness to prosecute if that witness is of good quality. If it's a poor quality witness with questionable credentials, then you need multiple people to confirm the story. But Larpent is very surprised by this. This isn't how civilian courts operate. But Manners Sutton, the guy who oversees the whole system, goes, no, I'm surprised that you think that that's a problem. This is absolutely okay. So, punishments. Having proved the case, what happens when it comes to punishments? Well, here's a little bit of an issue. So you can cross-examine a witness. That is permitted. Court proceedings show that the officers can do that very well. For the NCOs and privates, less so. And again, I want to use a Canadian example here. So whilst being tried for desertion in July 1813, Rufus Moon of the Canadian Regiment asked his witness, who claimed that he'd taken Moon's musket from him by force, when you clenched the gun, did I not ask you to let it go, and I would be your prisoner? Now, what Moon is trying to do here is he's trying to suggest that violence isn't needed, which would therefore have meant that it was harder to prove that he had no intention of ever returning to his unit. But, as you just heard, it's an awkwardly framed question, and it leads to an inevitable, uncompromising response. No, but I told him that he should not have the gun, for he was my prisoner, and he offered me $5 to let him escape. Perhaps unsurprisingly, Moon had no further questions for that or any other of the witnesses, was found guilty of desertion and shot. So, when it comes to punishments, the thing that I want to dwell on here is the reason why we have a bit of an issue with witnesses during this period. And Wellington complains about this. He just is furious with civilians who raise these cases and then don't turn up for the trials, and he can't understand it. But what I'm going to do is very simply demonstrate the reason why that happens. On the left, you have a selection of punishments, and granted, you're going to have to trust me that these are representative, for making away. Making away was basically taking a part of the army's equipment they've given to you, whether it's your gun, whether it's your shirt, your blanket, and selling it to use that income to buy food or buy a change of clothes or whatever it might be. Now, you'll see that many of these cases resulted in the soldiers being put under stoppages. In other words, the army recoups the cost of that equipment from the soldiers' pay. The army doesn't want to be out of pocket. That makes a lot of sense. Now have a little look at some of the punishments for theft or plunder, and you can see the difference. Stoppages were incredibly, incredibly rare when it came to trials for theft and plunder. I went and counted this afternoon just to be sure for this talk. It happens 18 times in 11 years. And you're talking somewhere in the region of 600 or 700 cases of desertion being tried. What this therefore means is the army doesn't recoup the cost, and the defendant, the person being accused of the crime, is not ordered to repay the cost in the majority of cases. Now that is significant because if the army's not paying and the defendant isn't paying, nobody's paying. And we know the army isn't paying in these cases because if the army had paid, they would have recouped the cost from the soldiers' pay as they did with making away with their equipment. So this is why in many cases the witnesses are not turning up, because not only have they got the cost of traveling to wherever the court is and the accommodation, they're not getting anything out of it. Effectively, they are being failed by this system because it doesn't have a facility. There is no legal provision by which they can have their goods, the cost of their goods restored to them. In terms of how these sentences are reached, these are just a couple of examples of voting sheets. Effectively, what happens is each person writes down their name. They write firstly the verdict, fold it over, pass to the next one, and it's passed down the line. And you have the most junior officers who pass their verdict first, so that there's no influence from higher ranked officers. These aren't actually examples of the voting sheets. These are transcripts. The reason I know they're transcripts is they're all written in the same handwriting. So you haven't got the individual's handwriting to show that actually these were used in a courtroom. And then the same process is done once you establish what the majority decision is or whether or not they're guilty. You do the same process for the sentence. These examples are from Southampton City Archive, and the reason that I flagged these is that, again, they relate to Canadian examples. If you're particularly interested in seeing transcripts from Canadian regiments during this period, you want to go and have a look at the Page and Moody papers in the Southampton City Archives. The building looks very grand. In actual fact, the archives, I'm afraid, are sort of stored in a basement around the back somewhere. But they are a great resource. They're a lot of fun to have a read of. And you also get some general regimental court-martial transcripts in there, which are much, much rarer than the standard general court-martials, which you can find at Kew. So again, moving very swiftly on, we have another of those beautiful paintings from Moreland. The reason I flagged this one is that it is entitled Deserter Pardon. So that guy that you saw being apprehended earlier has been pardoned for his crime of desertion. And this is an important point. Even when the army has stated what will happen, when the military law has been considered and the court has reached its decision, you can still be pardoned for your crime, either by the king or the commander-in-chief who review the sentences, or the prince regent who reviews the sentences when the king is incapacitated, or by a senior commander, or by the guy overseeing the punishment parade on the parade square. There are plenty of examples that we could use of this. Crawford is a famous one where somebody appeals to him, citing an instance where they shared biscuit with him during the Buenos Aires campaign. He becomes very emotional and just counsels the whole thing. It's by no means the only instance. I won't dwell on them now for the sake of time, but it just shows, and it's a useful corrector to this idea that the army is obsessed with flogging. That doesn't mean the army isn't invested in the lash. If you consider the top two tiers of court, the general and general regimental court martials, 1.4 million lashes are issued in an 11-year period. And of those, only 12% are commuted. So, yes, the army does love to flog. But just as the army loves to flog, so individual officers love to intervene. I'm not going to read this quote to you because you can read it yourself, but this is George Simmons intervening in the flogging of a soldier. The reason that this guy is flogged, according to this commanding officer, is because he needs to make an example to his men. He has to make that example. That's what military law is there to do. He needs to make sure that the message is clear to the rest of the troops. He doesn't want to do it. And so he asks George Simmons to preside over the flogging and offer his professional opinion when he thinks the man has had too many lashes and can't take any more. Simmons does that far earlier than he needed to, certainly far earlier than was actually necessary. The guy could have been flogged a little bit more, but he's playing a game. He's sending a message to the other soldiers of the unit saying, look, I'm a good guy here. If you commit a crime, you will be flogged and you will be punished, and I expect that to be the case. But if you're a good soldier, I will step in and I will have your back, literally have your back. I will save your back from a flogging. And that creates a very strong bond because you show that you are not an authoritarian, draconian individual. And so from a command and control perspective, you have the will of the rank and file. You have a much stronger bond of willingness to comply with your command rather than coercing them into doing as you ask. And if you want another example of the way in which we've been generally within historiography too kind of focused on this idea of flog and flog to death, just have a look at Ilya Berkovich's book, Motivation in War. He talks about how within the Prussian army, again, we've kind of just been utterly unrealistic in how we've approached this idea of excessively draconian force being used because of this question of command and control. I want to get to some examples, and this was something that I did very deliberately for this talk. So I went through the court-martial database and I pulled out some examples relating to trials that take place out in Canada. You'll see a question on the right-hand side. I'm hoping that enough folks have stuck around this far to just pose some guesses about which might be the worst units posted in Canada during this period. And I'm wondering if sort of a more general knowledge of the War of 1812 amongst some of the listenership might therefore mean that some folks have got a better idea. So please post your comments in the live chat, and we'll see if anybody hits on the big ones. So you've got 148 trials. That's a very small proportion. What's quite surprising is that the disparity is skewed very heavily towards general court-martials. Actually, when the GRCMs are brought in, they are used far, far more heavily. And you see GCM trials starting to drop away and the GRCM sort of taking up the slack. In terms of the distribution across ranks, massively focused upon the privates. And the reasons for that are going to become really quite clear in a moment. That is out of character for the British Army during this period. You would expect to see a much better distribution across all ranks, both officers and NCOs in there, but very few. Notice no sergeants being tried. So this is very much a fixation on the conduct of privates during this period, and I would suggest sending a bit of a message. There's also a question of perhaps the rank and file, the NCOs deployed in Canada, having perhaps been out there on garrison duty for longer, are slightly more dependable. And so what you've got here are people who you can trust in positions of greater authority, so you don't need to try the sergeants and the corporals because they are fundamentally good eggs. More lieutenants than ensigns being tried, that's absolutely standard. There's something about lieutenants in the British Army during this period that just means they are far, far worse behaved than the ensigns. The ensigns, I suspect, being new to the rank, being the youngest in many cases, though not all, obviously, probably a little bit more inclined to be well behaved. Tom, have we got any guesses about worst behaved units at this stage?
We have several, and I wanted to point something out about around lieutenants. I found quite often that lieutenants would have command of companies. Captains were away, they had a brevet rank or were ill, so maybe the lieutenants were kind of in the mix of things. Some good guesses in the chat. I see the Royal Scots, Canadian Fencible Regiment, the 49th Regiment, the 41st Regiment. I would lean towards the 49th because they had a well-known mutiny at Fort George, which resulted in some executions for the ringleaders. So how'd we do?
Not bad, but nobody picked the top one. So the top one, as you can see, is the 37th. Those are all desertions. They have a big spate of desertions and there's a big crackdown. And that's what happens there. So all 15 of those are desertion cases. De Watteville's regiment comes in at number 2. But yes, the 49th, 10 there. Canadian Fencibles, 7. So you managed to get some of them. The 100th and the 103rd also cropping up there. And a number of the 103rd cases, I believe, are the ones that are in Southampton City Archives. So if somebody's got particular interest in that unit, go have a little look there. In terms of distribution, I include the data on the left simply because it's a really nice corrective, first of all. Sense of scale, this is 0.01 to 0.05 of a percent of all the trials that are happening in any given year. So crime is not particularly bad in Canada during this period. These are good statistics. Yes, granted, you've got to then factor in proportion of army deployed, but even so, these are very small numbers. What I also quite like about this is I think you see 1812, War of 1812 effect here. So the numbers kind of grow up to 1814, 15, and in the army as a whole, you see numbers tailing off in 1814 and 1815 as the Napoleonic Wars begin to be wrapped up, particularly on the European continent. So what you see in terms of that growth of numbers is just more troops being deployed and more tension in the system as they've got to make sure that everything is working smoothly within the regiments. So charges, this is why you see so many privates being charged, in my opinion, because they're fundamentally trying desertion, and it's massively skewed in terms of proportions. So as a whole, if you take GCMs and GRCMs, it accounts for 42% of all trials during this period. And as you can see, actually, you're talking 67, 70 odd percent of trials in Canada during this time focusing upon desertion. There's this very kind of heavy emphasis on that. We could explore the reasons for that open-ended question. I'm happy to discuss that in questions if people want to. What's very surprising.
I'll jump in for a sec. You know, there was a real problem in the Canadian theater because the bordering country also spoke a common language. So it was very easy for desertions to cross the border and slip away. And then there were also instances, so I covered that in some of my 41st talks, where a large number of 41st were POWs and Americans were actively recruiting prisoners, encouraging them to desert and join the American Army. So that, and then I was surprised to see the 37th. They're practically unknown in terms of their association with Canada in the War of 1812. So my guess was they might have been part of the Plattsburgh campaign, where you had a lot of Wellington's peninsular armies, and they were quite disgusted with the mismanagement of that attack on Plattsburgh in New York. And apparently there were quite a number of desertions as those soldiers were being marched back towards Canada. So anyways,
yeah. You see a lot of that first point playing out in the trial transcripts as well when it comes to Canadian regiments that are out in Canada. And there's lots of questions about, you know, could Private X have crossed this river, because the river represents a boundary between different spheres of influence for different forces. And, you know, cases can kind of swing on these questions of, could you have physically joined the enemy to therefore kind of verify whether or not you're deserting to the enemy or not? Plunder and theft, very, very low. Plunder and theft is usually something like 13, 14% of cases. So for only one case to come through is very unusual. And the other thing I want to just focus on here is proportion of punishment. So flogging up there as the highest, that's not surprising. So if you take flogging, execution, imprisonment, and transportation or general service, those are all your typical punishments for desertion, which is why they figure most highly. In total, and I did go and count this up, you've got 44,650 lashes issued across the general regimental courts martial over this period. So some little stats for you to take away there. And so I want to finish this talk, for those of you who have very kindly kept with it, and thank you for your patience, not in a courtroom and not on the punishment parade square, but somewhere, frankly, far worse, on a battlefield. This is Lady Butler's famous painting of the 28th at Quatre Bras. It's probably my favorite painting ever for the way in which it captures that myriad of emotions that men experienced in the midst of battle during this period, and frankly, before and since. To stand on the battlefield, armies required discipline amongst their men, quite obviously, and a strong bond within the unit. Part of, but not all of, that glue that held those units together was, of course, the discipline system and the way in which it was implemented. What you've heard this evening is the story of a system that, yes, could be absolutely awful. Floggings, of course, they were brutal. Executions, even more so. And if you focus on that aspect, it's very easy to come away with that perception that Roger Norman Buckley did when he described British military law as terror and torture as public spectacle. Yet that only represents one side of a very complex coin. Military law was messy, yet frankly, it's that messiness that makes it so compelling. It was contradictory, and actually the manner in which it was applied varied depending on who you are. We haven't talked any great length about Wellington's perspective tonight. Again, if you want me to talk about that, pop a question in the chat. It cannot be denied that military law failed civilians. Of course it did. These are not courts of restitution. And with the army officers employing discretionary practices to their full extent, turning blind eyes to crimes, civilians in effect become victims twice. Firstly, being wronged by the soldier, and then by the officers who fail to take those incidents seriously. But fundamentally, military law existed to make scenes such as those in Lady Butler's painting a possibility. The way in which it was applied and ignored and twisted and manipulated all represented its fundamental strength. This was a system that was known to everyone. They knew what it said, they knew how to navigate it, and they knew how to attempt to escape punishment if they were caught out. They knew their officers' attitudes towards crimes and punishments. They knew what would be ignored and how that could be played to their advantage. Adaptable, clear in many cases, full of consequence, yet possessing safeguards against tyranny, the military justice system, flawed as it unquestionably was, enabled the army to fulfill its primary function, to instill units with the tensile discipline to fight and fight well. And by that measure, it was incredibly effective. Thank you.
Wow, thank you, Zach. This is far more complex, as you started out, far more complex subject than simply, the parade square flogging that we've all sort of envisioned. I've got lots of questions for you. I'm wondering, we're going to start with a few just quick clarification questions, if that's all right, and then we've got a few that are really big topic questions that we'll see how many we get through, how in depth you want to go on that one. So the first one quickly, transportation. What as a punishment? What would that mean?
So that is, bear in mind at this point, Britain is starting to ratchet up its kind of system of transportation. Transportation dies away actually with the loss of the American colonies. And I'm talking here within the civilian legal system. So there is this process of transporting people to the New World because it's a convenient way of getting rid of people who you consider to be morally suspect, inverted commas, during this time. Of course, once the American colonies become independent, that all changes. And so it dies away for a bit. And then people kind of latch onto this idea that why don't we just put them on the other side of the world? Send them to the colony in New South Wales. That's the best thing. And so you start to see it climbing again, but only climbing to a point. And so this idea of transportation, it varied. So sometimes it would be for 7 years, sometimes for 14 years, sometimes for life, depended on just how serious the offence was. Again, you could question, is transportation a death sentence because of the nature of the journey? We won't get into that here and now because that's a whole talk in itself. But what you start to see is, I mentioned Charles Manners Sutton, the guy who oversees this system, the Judge Advocate General. He's in charge with not only making sure that the law is applied and applied properly, he's also charged with the accounts. And he's the guy who's looking at this cost of transportation. He turns around and says, can we find a better way of punishing these guys rather than transporting them? Because it's incredibly expensive. Just do something else with them, flog them or can you try solitary confinement instead? He doesn't like transportation purely because of how much it costs. But fundamentally, they're meant to be sent to New South Wales and left there for a certain length of time.
So would that be generally a punishment for officers, or would that be soldiers as well?
Oh no, this is something that I didn't touch on because of time. There's a very two-tier system that operates here. So for officers, you're talking about honor-based punishments, basically. So you're talking private reprimands, public reprimands, suspension of rank and pay for a series of months, and then the most serious, dismissal from His Majesty's service and cashiering. Difference between those two is if you're dismissed, you can reclaim the cost of your commission. If you're cashiered, you cannot. So you take a big financial hit. Whereas, as we've focused on for much of this talk, for the rank and file, they don't get private and public reprimands. What they get is floggings, fines in some cases, though not as many as you might expect. Branding in the case of desertion. This is something that people haven't kind of looked at, but there are two ways of doing this. One is to get an iron, as you might imagine, and put it into a person's body. The other is to tattoo it using gunpowder. And so you place the gunpowder on the person and then ignite it, which sounds utterly horrendous as a way of doing it. Quite odd, though. You'd expect it to be visual, the location of this. You'd think, on the forehead or on the cheek or something, but no, it was meant to be done something like 6 inches below the right armpit, which is quite odd because then it can be disguised. So in the one sense, you want to put a dishonorable mark on this person's body, but you don't want to make that dishonorable mark too visible. So do you want the visual reminder or don't you? It's all a little bit peculiar. So yeah, no, officers would not be transported. They would just be sent home, or privately reprimanded or publicly reprimanded.
And actually, that's a nice segue. To what extent would a reprimand damage an officer's career?
That's a great question. It depends on the nature, not least because public or private. If you've been on trial, obviously that's going to be a black mark against your name. This is why the officers fight so hard, because this is an age of honor and honorable conduct. Before this period, there is a lot of kind of chicanery around trying to use military courts as ways of clearing your honorable reputation. And some of the acquittals that are issued are honorable acquittals, to the point where in one case during the Peninsular War, an officer is honorably acquitted after he visits a brothel and is supposedly kind of spending the evening afterwards running through the streets and kicking up a fuss. He's acquitted of kicking up a fuss, but Wellington steps in and vetoes the honorable acquittal because the guy's been to a brothel, and in Wellington's head, there's no way that you can describe that as honorable. And so he steps in and he puts this in the general orders. So this thing goes out to the entire army, where he says, look, this guy's been doing this, not honorable, I'm not having it. So it all depends on the nature of the crime and the manner in which they are found guilty. But yes, certainly, the rumor mill would kick up and it would be known that, you were tried for X, and to what extent was that legitimate or not.
Right, interesting. And of course, the officers' mess is going to be that same social group as the men's mess, right? So where you fit into that officers' mess is exactly the same for the men. So just at
precisely,
a different level.
But even more complex because you've got honor built into this. One of the things we haven't talked about is dueling, which is a messy situation. Eamon O'Keefe did a great paper on this a couple of years back at the 2019 Wellington conference. And what he'd found is that you've got situations where, because dueling isn't permitted because it's basically bad for business. You can't have your own officers killing one another. And what that therefore means is that it is illegal. And yet, if you reject the challenge for a duel, that is seen as dishonorable because you haven't had the moral fiber to stand up and fight, inverted commas, like a man. So if you do the right thing, you're damned. And if you do the wrong thing, you're damned. And so it becomes this very complex thing. And there are instances where people are really being tried on trumped up charges that all stem from the fact that back along, they're issued with a summons and they didn't have the moral fiber that was expected of them. And yet at the same time, if you ridicule for somebody for doing that, that is actually explicitly a charge under the Articles of War. So you've got people breaking the law who, in order to encourage people to break the law, it's all very messy. You can see how complicated this whole thing kind of goes around in circles. Absolutely.
So turning quickly, hopefully not too long, to one of the bigger issues. Women on the strength, on the regiment, would military law apply to them as well?
It would. You see very few women being tried, though. I'm trying to remember the exact number off the top of my head. I used to think it was 2, and then I rechecked the figures and found that actually it was something like 4 or 5. But bear in mind, that's 4 or 5 out of 9,227 cases. What's quite interesting is how they're described. So they're described as a wife of Private X or Private Y. So there's a lot kind of tied into ownership, and these women are associated with a man. I don't think any of them are actually flogged. I think in all of the cases that I've got, they're acquitted. Some of the cases are quite odd. In one instance, it involves a woman acquiring a musket and firing into a house, but nobody's actually punished. There are some nice little anecdotes that certainly suggest that women could have been punished, but there's nothing that conclusively indicates that yes, they were.
Interesting. And then again, turning to Marcus, this could probably be an entirely separate topic, but he's wondering about sort of the regimental reputations that certainly existed in the early 19th century, and we have these visions of them today. So, for example, he mentioned the 88th, that we have this vision of being sort of a hard fighting regiment, but not particularly disciplined. And then at maybe the other end, you have the 95th Regiment, who we see as, not a flogging regiment where they, they're kept in control by other means. Do those reputations, are sort of views of those regiments, do they hold out over time, or are they more myth?
It's a great question. Thanks, Marcus. They sort of do and they sort of don't. So you've got an issue here with a lot of my work has been with regimental court-martials. Now, regimental court-martial returns don't have to be included in the reporting of the regimental inspections until 1811, and after that point they appear with growing frequency, but not complete frequency. And so you have a very incomplete picture. What's very noticeable, though, to answer the question about the 88th are the worst of all the regiments that I surveyed. So I surveyed 25 regiments at regimental court-martial. I did everything at general court-martial, everything at general regimental court-martial, but then the RCMs I had to sample, just because of the scale of the material, it's going to take the rest of my life otherwise. And what I found was that the 88th, yes, absolutely, you've got over 300 individual trials over the course of this period that remain available to us to assess. Now you get to the 95th. The 95th have this reputation that they don't flog. The 95th came something like second or third on my list in terms of most number of trials. Now there's a question there. Is this just because the 95th are returning their transcripts of trials that have taken place more frequently? Or is it that actually we just have this perception of the 95th that we've overstated up until now? I think the 95th flogged. Yes, there is this kind of culture of try and flog less when you can, but it doesn't mean that they don't flog when they need to. And you've got to think also about the way in which the 95th is deployed. And there is some truth to this idea that, particularly when they're fighting Crawford as part of the Light Division, that they are amongst the vanguard of the army on occasions. But with that comes greater opportunity to commit crimes, to go plundering, to desert, because you're further removed from the central command hubs. So is this a case of circumstance? Is this a case that we've inflated the reputation? Is it just that they're really good at record keeping? I think it's probably a bit of all three, but I do think that we need to just kind of temper this idea that the 95th were never flogged, which I do see bandied around on occasion, that they were far and away the best behaved. Actually, when you look at their desertion stats are not particularly great. There are other units which we don't associate with great morale, where they have lower desertion stats. And that's not to say the 95th have a desertion problem, but we do need to be a bit more cautious, I think, about going, 95th should be put on a pedestal as the epitome and the greatest of reputations when it comes to their conduct during the Napoleonic era, which is an unpopular opinion.
Yes, that's interesting. I hope that's not going to lose us too many viewers, because I would like to ask you to give us some more information about your charity. Just we've still got lots of people on, so maybe you could do that while we still got them on.
Perfect. Thank you very much. I deliberately cut this out, folks, so that you could run away screaming if you've had enough about crime and punishment. But I'm not going to talk about crime and punishment as I talk about this organization very briefly. We've talked a lot about men tonight who have experienced some real horrors in the course of their campaign. And we reach the end of a memoir and we close the book, and we never know what happened next. And in some cases, we do actually know that nothing came next. And, they met tragic ends on battlefields. In other cases, of course, they made their way home, but we don't know much about their stories after. Now, we have a tradition, particularly in Western Europe and the Western Hemisphere as a whole now, that if somebody falls in the course of battle, they are honoured. And that's something that's happened in the wake of the First and Second World War. Quite obviously, organisations like the Commonwealth War Graves Commission, kind of that culture, so many people dying in those conflicts, leading to a change in the way in which the war dead were treated, and quite rightly so. What folks often don't then contemplate is the fact that if you track back before that, there's nothing. There is no organisation that covers them. And you might go, well, is this really an issue? This is 200 years ago. Well, actually, you'd be surprised. Yes, it is. So there is no organisation out there that is dedicated to maintaining the graves of those who survived from this period. And perhaps more worryingly, there is no organisation that is dedicated to burying the remains of those who fought and died during this period when they are disinterred. You might say, well, is that even an issue? Actually, yes, it is, and increasingly so. So we have examples like the ossuary, which is the middle photo that you can see. That's in La Dernière Quartier, just south of Waterloo in Belgium from the Waterloo campaign. In there, you will find the bones of an unknown number of individuals, because they are just bones that have been found in the process of farming. And they've all been chucked into this brick hut, effectively. Now, is that how we treat the body of a war veteran? I don't know. I would suggest probably not. You also have instances of the bodies, more complete bodies of the war dead, being put on display in museums or being held in storage facilities. Now, the point of this charity is to offer the opportunity to change that. There is a fundamental belief within the Napoleonic and Revolutionary War Graves charity that regardless of how you died or why you died, if you served at any point between 1775 and 1815, regardless of your nationality, regardless of cause, you deserve the humanity of a place in the ground. And that's what we seek to do. So we are a new startup charity. We will be opening ourselves up to membership at the end of this month. And the fundamental focus is in cases where remains are disinterred, we seek to work with those local authorities and those who discover those remains to study them as a prerequisite to then get them buried. So we learn everything that we can about them. So there is no sense in keeping them anymore, because we're just waiting for some new idea to emerge in the future where science will be able to unlock something else. Well, that's another thing entirely. But the idea is that if we can't learn anything else from them at this moment in time, can we just give them the dignity of a burial? So that's the first aim. We also look to maintain the graves of those who survived. And, those graves have fallen in many cases into disrepair. You've got examples on the left and right of your screen. And so we're looking to work to restore those graves to a semblance not only of cleanliness, but also of decent state of repair. And we also have a whole educational program that we're working on, and we seek to further research into these people's lives and experiences. You can find out more about our work on Twitter and Facebook at NRWG Charity. We had a launch event a few months back. You can find that on YouTube. Just search for NRWGC or Napoleonic Revolutionary War Graves Charity. We will be launching a volunteer program in the very near future to help us gather information about the tens of thousands of graves across the world and their states of repair. We have an international team that we've built. This is not an Anglo-centric focus by any means. So we have folks from the US, from Canada, from Spain, from the Netherlands, all coming together to make this concept viable. So if you've got any questions about what we're aiming to do, if you would like to get involved, if you'd like to join our mailing list to stay in touch with what we do, please email nrwgcharity@gmail.com and we'll get in touch with you very soon. Thanks very much, Chris.
Fantastic. Thank you. And I'm going to go out on a limb and say if people would like to donate to your charity, they can send an email and sort of get in touch with you and organize it that way.
Absolutely. That would be fantastic. The more we know about what we'll have in terms of income, the better we can plan for the future, ultimately.
Fantastic. Well, thank you so much, Zach. The comments are rolling in with people who have just found this a fascinating topic. So thank you very much for your time this afternoon, this evening, taking a Saturday evening for us. This was fantastic. Like I say, an incredibly complicated topic that really opened up for us. So thank you. And I'm going to turn it back over to Tom.
Not much more to say other than thank you so much, Zach. Thank you for everyone who joined us this afternoon. We really appreciate your support. Do subscribe to the channel. Do follow us, whether it's our Facebook page or our Twitter account. And if you got a little extra change, do consider a donation. It helps us put on these sort of products. So thanks again, Zach. Thank you, everyone. Have a great afternoon or evening, depending on where you are in the world.